What gets you disqualified?
A lot of things.
Oh, great. How did you get disqualified?
No.
I'm crossing my focus on something. Also, I need a statement. Statement. Why again? I don't know what to do this. What is it? Change time teaching. Oh.
You get on your phone, you set a timer when we start.
And pause every time we interrupt.
We can also chat through Zoom. So
And do I pause it?
pause it during objections, yes.
And then I restart it again.
After the objections are over and the questions.
Oh, so he is supposed to pause it after?
That's all I do?
Yeah,
That's all it
let
is?
us know how long we have left.
Well,
Okay.
Okay, good morning. My name is Marna Lake, and I'm the presiding judge this morning. First of all, let's do a check-in and make sure that everybody is here. And I'm just going to unmute everybody. Or try to. So that everybody can let me know if they're here. And I haven't been able to do that with everybody. If y'all can unmute yourselves, go ahead and try to do that. Great.
And Judge,
Yes.
I'm sorry to interrupt, but
Don't feel free.
This is one of the coaches. It looks like we're missing a number of folks from one of the schools, and it looks like that it says I'm getting one of my students that says the host needs to let them into this meeting. So there may be something that says admit people.
I did. I had admit all, but I'll try it again. Oh, and here comes some more. Here we go.
Perfect.
Great. Thank you for your help.
Of course, that might come up a couple more times. So I just wanted to share that. It looks like we have a bunch more now.
Okay, and actually, if you want to let me know, since you would know if everybody's here, I'd appreciate that.
I can tell you the prosecution looks like they are all here, Your Honor. Thank you.
All right.
Your Honor, our attorneys for defense, we have to share a computer, and our coach will explain.
Okay.
Yeah, we're at school. We didn't have the computer access for everybody individually, and so we're set up all over the building.
All right. So does it look like everybody's here now?
Tess, are you guys good?
Yeah, we're all here.
Where's your, oh, I see Juliet right here. So I see
Yeah.
the witnesses are here as well. So we should be good.
All right. Again, some of you hadn't let in yet. My name is Marna Lake. I'm going to be the presiding judge today. So first of all, I'll ask, as far as the prosecution, is the prosecution prepared to proceed?
Yes, Your Honor, after a few preliminary matters.
All right. And is the defense prepared to proceed?
Yes, Your Honor, we're ready.
Thank you. All right, as far as the prosecution, well, first of all, what I'd like to do is have everybody identify themselves and let me know what role you are playing. And what I'm going to ask each of you to do, I'll trust each of you to mute and unmute yourself, and then mute yourself back when you're finished. So if someone wants to speak on behalf of the prosecution, and let me know who is your name and what role you are playing.
As the scoring judge, if you could do that as slowly as possible and spell last names, because we're not able to see your full names on the screen, that would be helpful to us in keeping track of who's doing what.
Hello, my name is Hannah Feeney, Feeney. I will be giving the opening statement, conducting the direct examination of Alex Cifuentes, and the cross-examination of Avery Becker.
Good morning. My name is Anna Carrington, Carrington. I will be conducting the direct examination of Detective Jordan Markowitz and the cross-examination of Professor Blake Van Owen.
Good morning. My name is Annika Buchin, Bucchin. I will be conducting the direct examination of Kyle Kuzak, the cross-examination of Taylor Perkins, as well as presenting the closing argument. May our witnesses please introduce themselves?
Please.
Good morning. My name is Grace Oliver, Oliver, and I am Alex Cifuentes.
Thank you.
Good morning. My name is Kate Malloy, Malloy, and I am Detective Jordan Markowitz.
Thank you.
Good morning. My name is Pilar Melendez, Melendez, and I am Kyle Kuzak.
Thank you. Now the defense team.
Yes, Your Honor. May we proceed?
Please, if you could introduce yourselves.
Right. My name is Tess Orr, Orr. I will be delivering the opening statement, conducting the direct examination of Taylor Perkins, and the cross-examination of Alex Cifuentes.
Thank you.
Good morning, Your Honor. I am Anders Griffin, Griffin, and I will be playing Avery Becker.
Thank you.
I am Albert Booth, Booth. I'll be conducting the direct of Avery Becker and the cross of Detective Jordan Markowitz.
Thank you.
My name is Nicholas Huffman, Huffman. I will be conducting the cross-examination of Kyle Kuzak as well as the direct of Blake Van Owen, and providing the closing statement.
Good morning. My name is Juliet Berry, and Berry, and I will be playing Taylor Perkins.
Thank you.
Good morning. My name is McKinley Baum, Baum, and I will be playing Blake Van Owen.
Thank you. All right, and I think the prosecution had, I believe you stated you had some preliminary matters.
Yes, Your Honor.
Go ahead.
At this time, we ask that all witnesses put their pronouns in the chat. Would the court order the all witnesses to put their pronouns in the chat?
All right. Oh, okay, I see what you mean. Got it.
And we would like to clarify some of the procedures of this online trial. Specifically, the prosecution will be admitting evidence pursuant to Rule 7.4 of the Rules of Competition. As such, any document shown on the screen will be assumed to not be shown to the jury unless we specifically ask to publish. And we will only ask to publish when we intend to show it to the jury after admission. And would Your Honor like us to ask permission each time we intend to show an exhibit, or may we have permission now?
No, you have standing permission to do that.
And may we have standing permission to zoom into or otherwise modify exhibits for clarity?
Yes, you may.
At this time, I would like to remind the court that sequestration is not allowed pursuant to Rule 5.3.1 of the Rules of Competition.
Yes, I'm aware of that. Thank you.
And does Your Honor intend to constructively read the jury instructions before or after closing argument?
Well, let's take that up at that time, at the end of the evidence.
Yes, Your Honor. And at this time, we reserve any remaining time from our closing argument for rebuttal.
Yes, that'll be granted as well.
And while all members of the team have made the best efforts to be in a place with the best internet capabilities possible, if at any time you are unable to see or hear us clearly,
And I think that just happened. I think you're frozen. Go ahead.
Can you hear me now, Your Honor?
Yes, you just froze for a bit. Go ahead.
While all members have made efforts to be in a space with the best internet capabilities possible, if you are unable to see or hear us, please feel free to interrupt us.
Oh, I will, believe me.
And that is all, Your Honor.
Thank you. Did the defense have any preliminary matters?
Yes, Your Honor. Pursuant to Rule 4.6, we would like to introduce stipulations to the court. The stipulations have already been agreed upon by the prosecution and the defense.
And I'm sorry, you cut out just for a second. Were you wanting to introduce those stipulations now, or were you just telling me about them? Okay. Sure, go ahead.
Would you like me to read the stipulations out, or I can screen share the stipulations?
That's whichever you prefer.
All right, I will just read them out.
Sure.
First, the signatures on the witness statements and all other documents are authentic. 2, the chain of custody for evidence is not in dispute. 3, stipulations cannot be contradicted or challenged. And 4, Exhibit 22 is a copy of a recording of a portion of the court proceedings against Jonathan Rollins.
Right. And I understand that those stipulations have been agreed upon by both sides. At this time, I would like to administer an oath. If everybody, well, first of all, let's start with the team members. Team members, if you would please raise your right hands. Do you promise that the presentation that you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
We do.
Thank you. Now, if the witnesses could raise their right hand. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, and that you will not add material facts or opinions which are not contained in the case program, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Thank you. And I don't know if there's any gallery members. I know there's some coaches. So gallery members, including teachers and coaches, family members and friends, please raise your right hand. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this trial competition?
Yes, Your Honor.
Yes, Your Honor.
And scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes.
Yes, Your Honor.
Thank you.
Before we proceed, I'm
Yes.
wondering if we're short a scoring panelist?
We are.
We are, and I'm trying to locate him, Bill. If necessary, I'll step in and be a scoring panelist for this session.
Okay, and I am going to have trouble filling out my score sheet because I know there was as you entered the courtroom, it said there were two names for the prosecution and defense. I didn't realize I needed to write those down at the time, and I didn't. So what are the team codes for plaintiff or prosecution and defense?
Prosecution is Evans and defense is Crestone.
I'm sorry, could you repeat that, Mr. Starrett?
Sure. Evans is prosecution. Defense is Crestone.
And from my perspective, it would be helpful if when the attorneys begin their direct and cross examinations and also the witnesses are called, if they would repeat their actual names. I tried to get them down as they were being read, as the members are being introduced, but I'm not sure I have them completely, and I'd like to be accurate.
I think that would help all of us.
All right, and Mr. Starrett, did you need another minute to try to get hold of the other scoring judge, or?
Actually, he sent me an email and it says that he is in. So Chris, can you hear us? I wonder if he's in the wrong courtroom. Let me see. So I'm gonna leave for just a second and see if I can find him in another one of the courtrooms. I'll be right back.
Sure, we'll wait till you get back, Mr. Starrett.
All right. My apologies to everybody for having to wait so long.
Hey, that's all right.
Briefly, we would like to discuss that we are in our school building right now, and we do have announcements coming up in the morning, so we will be muting ourselves just to keep our school disclosed.
Your Honor,
Yes.
Crestone is in the school building, and we wanted to clarify that with being in the school building, that also means that announcements will be given. And so if at any point the announcements interrupt the proceedings, we ask that we can have the team members muted so that we do not disclose our school.
Understood.
Thank you, Your Honor.
Yes.
Okay, Judge Lake, I've gotten in touch with Mr. Ballard and he is able to hear everybody. It's just that for some reason we're not able to see him. So you now have a complete scoring panel. So I think you're good to go.
All right, thank you, Mr. Starrett. Was there any other preliminary matters we need to address before we start the trial itself?
No, Your Honor.
Oh, okay. Then the prosecution may give its opening statement.
Yes, Your Honor.
And again, as scoring judge asked, as each person gets up, would you please repeat your name and spell your last name again, just so that we make sure we have everything accurately written down. Thank you. Go ahead.
May I have a moment to readjust my courtroom?
Yes, you may.
Hello, my name is Hannah Feeney, Feeney. May it please the court?
Yes.
A mask can't hide the truth, and the truth is in the map, messages, and motive. It was Friday, March 6th, 2020. Mackenzie Brackman, a local defense attorney, was alone in his home on South Flower Street when a masked intruder tried to open his front door, but it was locked. The Ring doorbell security system was set off. The intruder went around to the back of the residence, and in a panic, the victim grabbed a kitchen knife to defend himself. When the intruder entered through the back door, a struggle quickly ensued over that knife. The defendant wrestled the knife away from the victim before stabbing him in the back. That's when the defendant ran. The victim tried to follow to the front door before pulling the knife out and rapidly bleeding to death. Mackenzie Brackman died in that home invasion. And that intruder's mask, Avery Becker's mask, can't hide the truth. And the truth is in the map, messages, and motive. After a thorough investigation, we charged Avery Becker with 2 counts: murder in the first degree and second-degree burglary of a dwelling. But to understand murder in the first degree, first we have to talk about second-degree burglary of a dwelling. It says that on or about March 6, 2020, the defendant broke an entrance into or unlawfully entered a dwelling with the intent to commit the crime of criminal mischief, which simply means to damage another person's property. Now, let's talk about first-degree murder. The judge will tell you that Avery Becker is guilty of first-degree murder if Mackenzie Brackman was killed by anyone while the defendant was committing burglary or in immediate flight from the scene. We will meet our burden and prove Avery Becker guilty of both of these charges because a mask can't hide the truth. And the truth is in the map, messages, and motive. Now, let's break that down. A map. You are going to hear from Detective Jordan Markowitz, the lead investigator in today's case. She will tell you about call detail records that put the defendant's phone at the victim's house at the time of his murder. You will hear how these phone movements show the defendant staying there long enough to commit the crime. Speaking of phones, Pay close attention to the messages the defendant sent to Miss Alex Cifuentes, a friend and teammate of Mr. Becker. She will tell you how this kind of mischief wasn't out of the ordinary for the defendant. After all, he had vandalized the victim's car only days before his murder. You will hear how in these texts, the defendant confessed to planning to commit this crime just before Mr. Brackman's home was broken into and he was killed. Now, we've heard about MAP, we've heard about the messages. Let's talk about the motive. You might be asking yourself, why on earth would a high school student commit such a crime? You will hear how the victim was the defendant's mock trial coach. You will hear all about the bad blood between them and how upset the defendant got when he was kicked off the mock trial team. You will hear from Kyle Kuzak, a crime scene reconstructionist who worked with Detective Markowitz on this case. She will tell you how the crime scene is consistent with the defendant's motive and how this was a burglary gone wrong, just like what Mr. Becker threatened to do in his text to Ms. Cifuentes. But for everything you'll hear today, you won't hear that the defendant intentionally killed the victim, because that's not what happened. Instead, this was a burglary gone wrong, and Mackenzie Brackman died as a result. But that is first-degree murder. A mask can't hide the truth, and the truth is in the map, the messages, and the motive. At the end of today's trial, it will be clear that Avery Becker committed this crime, and that is when my co-counsel, Ms. Buchin, will ask you to deliver justice for the victim and find Avery Becker guilty of both charges. Thank you.
Thank you, Ms. Feeney. Prosecution may present its first witness.
Your Honor, defense still needs an opening statement.
Yes, thank you, Ms. Orr, and thank you for reminding me of that. And actually, because of things the way they are, it's been a while since I've done a trial, and it's been a good year. So thank you, Ms. Orr. Please go ahead.
May it please the court.
Okay, Ms. Orr, you're muted. Let me try to, I'm
Judge, they
sorry.
were just taking that break that they had warned the court about.
Oh, got it. Okay. Just let Ms. Orr start when she's able to.
These may well be the longest announcements we've ever had.
Of course,
It
course.
it happens today, yes.
of
I
course it would be
apologize.
today.
Yeah.
Okay, may I proceed?
Please, Ms. Orr, go ahead.
May it please the court. Thank you, Your Honor, members of the jury and opposing counsel. Mackenzie Brackham was the beloved coach of the Colorado High School mock trial team. The mock trial team that my client, Avery Becker, was on. My client dedicated his high school career to becoming a lawyer. He spent all 4 years in mock trial working and striving to become a successful lawyer. My client was very good. And unfortunately, that led a lot of people to be jealous of him. And because of that jealousy, he's being falsely accused of murder. Unfortunately, Mr. Brackman and my client did not always see eye to eye. And that did leave a lack of judgment on my client's part. But there is a difference between defacing property and murder. My client is not capable of murdering his mock trial coach. Even though they didn't always agree, does not mean that my client would go as far as to stab his coach in the back. Detective Jordan Markowitz rushed through his investigation and rushed his judgment. And now my client is going through a trial of a murder he didn't commit. I ask you to listen during cross-examination because you will hear the holes and the flaws in the prosecution story. All the prosecution has to offer is a rushed investigation and lying witnesses. The prosecution will try and bring up text messages from Alex Fuentes, but the night of March 5th, my client's phone went missing. And if his phone was missing, how could he have a conversation through text message with his old teammate? March 5th, 2020 was supposed to be a regular day for the mock trial team and for my client. But Mr. Brackman had gotten into an argument with my client and decided to completely remove him from mock trial. The mock trial team that my client spent 4 years receiving awards for his work. My client went outside the school building and wrote Worst Attorney Award on Mr. Brackman's Porsche. Afterwards, my client offered to wash his car and get a job to pay for the repaint job, excuse me. He repeatedly apologized and he feels terrible about his actions. Later that night, he went to the fry shack where he saw Alex Fuentes. He got frustrated with their conversation and got up to go to the bathroom, leaving his phone on the table. That was the last time my client saw his cell phone. On March 6th, 2020, the day of Mackenzie Brackman's murder, Avery Becker woke up and realized his phone was missing. He went to pick up his friend Taylor Perkins. And they decided to retrace their steps from the night prior and look for my client's missing phone. They went to the local mall where they burned the whole morning looking for his phone. They then decided to go to the fry shack again and talk to the afternoon staff, where they had seen their old mock trial team, who had decided to go there because Mackenzie Brackham never showed up for practice. The reason Mackenzie Brackham never showed up for practice was because he was lying in his doorway bleeding out. Now I want to know, if my client was at the mall all morning with Miss Perkins, how could he possibly murder Mackenzie Brackham? When you are called back for deliberation, you'll find the prosecution left holes in their story. You'll find the prosecution did not meet the burden of proving, beyond a reasonable doubt, the existence of all necessary elements to constitute the crimes charged. I ask you to find my client, Avery Becker, not guilty of first-degree murder and second-degree burglary. Thank you again, Your Honor, members of the jury, and opposing counsel.
Thank you, Ms. Orr. The prosecution may present its first witness.
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand.
I'm sorry, Your Honor, but could the timekeepers have a moment to reset their timers?
Yes.
And before we begin, my name is Hannah Feeney, F-E-E-N-E-Y, and my witness is Miss Grace Oliver, O-L-I-V-E-R.
Thank you. The timekeeper, go ahead and let me know when you're ready to proceed.
I'm ready to proceed, Your Honor.
Thank you. All right, go ahead. Ms. Cifuentes is on the stand and she's been sworn in. You may
Your
proceed.
Honor, yes, Your Honor. Before I begin, this time I ask the court to order the defendant to turn his camera on for purposes of identification, after which he may turn it off.
Yes, that is ordered. If Mr. Becker could please turn on, or Ms. Becker could please turn on your camera for purposes of identification only. Thank you. You may proceed.
Good morning. Please introduce yourself to the jury.
Good morning. My name is Alex Cifuentes, and I'm a senior this year at Colorado High School.
How are you feeling about testifying here today, Ms. Cifuentes?
Nervous? I just want justice for my mock trial coach, Mr. Brackman. It's been really hard knowing that he's gone and that I'd have to tell a jury about what Avery did.
Now, before we get to that, could you tell us a little bit about Mr. Brackman?
Well, Mr. Brackman was an incredible attorney and an even better mock trial coach. He seemed to really care about everyone on the team doing their best.
And based on your observations and perceptions, did everyone else on the team have a good relationship with Mr. Brackman?
No, most people liked him, but his relationship with my teammate, Avery Becker, wasn't as great.
How so?
Well, they would argue at almost every practice. Avery didn't do things the way Coach wanted him to, and Coach called Avery out on it. It got so bad that Avery was kicked off the team 2 different times.
Do you see the defendant here in court today?
Yes, I do.
Could you identify him by an article of clothing and the title of his video?
Yes, he's wearing a bow tie and he has on a black mask. And the title of his video is Avery Becker.
Let the record reflect that the witness has identified the defendant subject to cross-examination, and at this time, the defendant may turn off their camera.
The record will reflect. And Mr. Becker, you may now turn off your camera. Please proceed, Ms. Feeney.
Yes, Your Honor. Now, you mentioned arguments between Mr. Becker and Mr. Brackman. Were there any such arguments in the days leading up to Mr. Brackman's death?
Yes, there was one 3 days before he was murdered, on that Tuesday. They were arguing about the competition that happened that weekend.
Tell us about that.
Well, Coach was telling Avery that he needed to put in more work before the state tournament. Avery got really upset about this. So upset he grabbed one of the Sharpies that we were using to write down notes with and stormed outside. Later, I found out he wrote on Mr. Brackman's car. He was kicked off the team the same night.
And to the best of your knowledge, did Mr. Becker ever attempt to get back on the mock trial team?
Yeah, he did. He even texted me asking if I'd be willing to talk to Brackman for him.
Now, I'd like to shift the focus to what happened after Mr. Brackman was murdered. Were you ever asked to come in for an interview by Detective Markowitz?
Yes, I was.
About what specifically?
Well, when Detective Markowitz first reached out to me, called me, I told her about these text messages that I had gotten from Avery a couple days before the murder, and she told me to come in for an interview at the police station.
And did you preserve these texts for Detective Markowitz?
I did. I didn't have my phone with me at the interview. I left it at home, but I screenshotted them and sent them to her. She said that was fine.
At this time, let the record reflect that my trial technician is displaying Exhibit 14 on the screen.
The record so reflects.
What is this exhibit, Ms. Cifuentes?
Oh, these are the texts that I was just talking about.
And just for clarification, whose messages are in green and whose are in gray?
The ones in green are the ones that I was sending to Avery, and the ones in gray are the ones that he was sending back to me.
And is this a fair and accurate portrayal of the, or fair and accurate depiction of the conversation you had with the defendant?
Yes, it is.
Your Honor, at this time, I move to admit Exhibit 14 into evidence.
May I have the position of the defense? Any objection?
I do have an objection, on Your Honor. This is hearsay.
Your response, Ms. Feeney?
Yes, Your Honor. This is not hearsay pursuant to Rule 801. The statements in gray are the ones made by Mr. Becker are not hearsay pursuant to Rule 801D2, as they are a statement of a party opponent. The statements in green made by Ms. Cifuentes are also not hearsay pursuant to Rule 801, as they are not being used to show the truth of the matter asserted, but rather to provide context for Mr. Becker's statements.
Is there any response?
No, Your Honor.
And was there a number or Exhibit 14? All right, Exhibit 14 is admitted.
May I publish to the jury?
Yes.
Now, Ms. Cifuentes, I want to draw your attention to the second text from Mr. Becker. What is this text referencing?
This is Avery telling me that he got kicked off the team and asking if I'd be willing to talk to Brackman to help him get back.
And how did the conversation proceed from there?
Well, I told him that I wasn't sure anyone could change Coach's mind after what Avery did to his car. And that's when Avery showed his true colors.
What do you mean by that?
Well, he went crazy. I mean, you can see he threatens to trash Brackman's house, that if he's still upset about what Avery did to his car, then he's going to be really upset when he sees what Avery does to his house.
Thank you, Your Honor. I have no further questions at this time.
Cross-examination, Ms. Orr?
Yes, Your Honor. May I proceed?
Yes.
All right. Ms. Cifuentes, I'm going to ask you a series of questions, and I ask that you answer in a yes or no format, please. You were on the mock trial team, correct?
That's correct.
And you were on the mock trial team with Avery Becker?
Yes, as I stated on direct.
But you believe the team would have been better off without Avery?
Well, yeah, I mean, it's kind of hard to have a really good team without everyone putting in their work, but last year we wouldn't have gone to state without Avery.
And then after Avery was kicked off the team, you said that you could win the Best Attorney Award?
No, I mean, maybe it'd be possible this year, but we wouldn't have been able to go to state without Avery. We'd be disqualified.
And after Avery was kicked off the team, he wanted you to talk to Mr. Brackman to let him back on the team. Is that correct?
Yes, as I just stated.
But you refused?
No, I said that I wasn't sure coach would let him back on the team, especially after what Avery did to his car.
And then after Mr. Brackman did not let Avery back on the team, you were excited to take on his role?
I wouldn't have taken on his role. I wouldn't have gotten any role. We would have been disqualified from state.
Okay, moving on. After Avery was kicked off the team, you saw him at the Fry Shack, correct?
A couple times, yeah.
The time that I'm referring to is March 5th. And you sat with him and Taylor. Is that correct?
No, I was sitting with the mock trial kids. Avery and Taylor came in after we did.
And the practice that Avery, the day that Avery got kicked off the team, you talked to him and Taylor. Is that correct?
I mean, I talked to them on the Tuesday that Avery was kicked off during practice, but that was it.
You, just for clarification, you're saying that you didn't talk to him and Taylor at the Fry Shack?
No, that's not true. You asked me if I talked to them the day Avery was kicked off the team.
So did you talk to Avery and Taylor at the Fry Shack?
Briefly, it was mostly Avery being upset, but briefly.
So in your witness statement, you stated that Avery let you use his phone. Is that correct?
Yeah, as far as I can remember.
And are you aware that Mr. Becker's phone went missing that night?
No, I'm aware that they think it's missing, but I didn't know that it went missing that night.
Okay. And you stated that in your witness statement, excuse me, you stated that we shouldn't trust Avery because of the experience he has in mock trial. Is that correct?
I don't think I state that specifically. I said that he's a really, really good witness, that he could pretty much convince anyone of anything, really.
You prepared a witness statement for today, is that correct?
Yes, that's correct.
And you signed your witness statement stating that if anything were to change, that you would change this witness statement?
Yeah, if any new or relevant information.
All right. Your Honor, may I pull up this witness's witness statement?
Yes, you may.
All right. If you will just give me a moment to find this, and then I will screen share. All right, Ms. Fuentes, will you please read line 129 to line 133, please?
Okay. Avery played several witness roles over the years, too. Avery always wanted to be a lawyer, I guess because that's where Avery thought the glory was. But Avery had this amazing ability to make things up on the witness stand and make you believe it was completely true. If this case ever does go to trial, the jury should be warned. Everything Avery will say on the witness stand will seem totally sincere and believable, but don't trust a word of it.
Your Honor, may I have a brief moment?
Yes.
So continuing, how long have you been in mock trial?
Well, this would have been my 4th year if Avery didn't kill Mr. Brackman.
And at this time last year, Avery was a senior, is that correct?
Yes, that's correct.
So you would have had the same experience in mock trial as Avery.
If Mr. Brackman was still alive this year, I guess so.
So then couldn't that statement be said about you too?
I never really played witness.
But you have the same amount of experience in mock trial as Avery would have last year.
Well, I don't have the same amount of experience. I mean, mock trial's not happening right now. So I have 3 years of experience as an attorney.
But you still have experience in mock trial, is that correct?
Yeah, like I just said.
Thank you, Your Honor. No further questions.
Thank you, Ms. Orr. Any redirect?
First, may I briefly inquire as to how much time is remaining?
Can the timekeeper advise?
You have 19 minutes and 14 seconds remaining.
Yes, Your Honor, briefly.
Go ahead.
Mrs. Fuentes, we heard a lot about about Mr. Becker's mock trial career. Did you ever bear any resentment towards Mr. Becker for his performance in mock trial?
Not at all. I mean, he helped us get to state, so obviously he was doing something right.
And to the best of your knowledge, when was the last time Mr. Becker had his phone?
To the best of my knowledge, he had his phone the whole time. I never saw that it was missing or anything, but
Thank you, Your Honor. No further questions.
Thank you, Ms. Feeney. Ms. Orr, anything based upon redirect, any recross?
No, Your Honor.
Thank you. Ms. Fuentes, you may step down. Prosecution may call its next witness.
The prosecution calls Detective Jordan Markowitz to the stand.
Ms. Markowitz, you are sworn in. Please proceed.
Yes, and Your Honor, just a reminder, my name is Anna Carrington, Carrington, and this witness is being played by Kate Malloy, Malloy.
Thank you. Thank you, Ms.
Good morning.
Carrington.
Thank you. Good morning. Would you please introduce yourself to the jury?
Good morning. My name is Detective Jordan Markowitz, and I'm a homicide detective with the Denver Police Department.
How long have you been involved in law enforcement, Detective?
I've been with the DPD for the past 13 years, 7 of which I've been a detective.
Do you have any unique knowledge or skills that you relied on in this investigation?
Yes, actually, I relied on my knowledge in cell phone data recovery.
Do you have any certifications in this field?
Yes, I do. I have cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement.
Have you applied this knowledge and skill in other cases you've investigated?
Absolutely. I use this knowledge all the time, especially given how prevalent mobile devices and their data are in today's society.
Your Honor, at this time, I ask that the court recognizes Detective Jordan Markowitz as an expert in crime scene investigation with an emphasis in the forensic analysis of cell phones and call detail records.
What is the position of the defense?
No objections, Your Honor.
Detective Markowitz is so recognized as an expert in the areas articulated by Ms. Carrington and may offer opinion as to those areas. Please proceed.
Yes, Your Honor. How did you become involved in this case, Detective?
I received a request for a detective, and I arrived at the scene of the crime at approximately 2:20 p.m. The first thing I took note of when I got to the scene of the crime was the fact that the door to the residence was open and the victim, Mackenzie Brackman's body, was just inside the doorway. I also took note of a large kitchen knife that was near the body.
So what was the first step in your investigation?
The first step in my investigation was to call in a couple of our teams. The first people I called in was the forensics team, and then I called in Kyle Kuzak, our crime scene reconstructionist.
Since Ms. Kuzak was the one who reconstructed the crime scene, we'll talk to her more about the specifics of the scene. But what was the next step in your investigation?
Well, while the forensics team was processing the scene of the crime, I gained access to Mr. Brackman's cell phone to download the contents and see if there was any relevant information.
Did you find anything significant on Mr. Brackman's phone?
Yes, actually, we found 2 pieces of information that were significant.
And what was that information?
The first piece of information that we found was that Mr. Brackman had a Ring doorbell app on his phone that actually captured the suspects both entering and leaving the home. The second piece of information that I found was that Mr. Brackman had a lot of recent contacts with a mock trial team, so that gave us a lead to follow up on.
Let's start with the Ring doorbell videos. Did you preserve each of those videos for trial?
Yes, I did.
Your Honor, let the record reflect that my trial technician is displaying exhibits 10 through 13 on the screen.
It will so reflect.
Do you recognize these exhibits, Detective?
I believe I do. However, they are a little small.
Your Honor, may my trial technician have permission to zoom in on these links so that my witness may properly identify them?
Yes.
So what are these exhibits, Detective?
Yes. These are the links to the Ring doorbell videos that I was just talking about.
Are these fair and accurate to the best of your knowledge?
Yes, they are. I reviewed them prior to trial today.
Your Honor, at this time, I move to admit exhibits 10 through 13 into evidence.
Your position, Mr. Booth?
No objections, Your Honor.
All right. Exhibits 10, 11, 12, and 13 are admitted into evidence.
Thank you. And we can take those down for now and we'll return to them on Ms. Kuzak's testimony. Now, Detective, you talked about a lead that you found on the victim's phone. Could you tell us more about that?
Of course. Like I was saying, the victim had a lot of recent contacts with a mock trial team. So we reached out to a couple of his students. The first person we reached out to was Miss Alex Cifuentes. It immediately became clear to me that she had some important information regarding the case. So I asked her to come on down to the station for an interview.
Did you learn anything significant from that interview?
Yes, actually, I did.
What did you learn?
Well, I learned that Ms. Cifuentes had been in contact with the defendant, and the defendant had been texting claims to want to break into Mr. Brackman's home and trash it.
Let the record reflect that my trial technician is bringing up Exhibit 14, which has previously been admitted.
It does.
Now, how did these text messages impact your investigation, Detective?
I'm glad you asked. These text messages show an important motivation that Avery Becker may have had to break into her coach's home. Furthermore, they're very consistent with the details that we collected from the crime scene.
Thank you. We can take Exhibit 14 back down. Based on this information, what did you do next?
I attempted to reach out to Avery Becker to get her cell phone, not only to corroborate the validity of those texts, but also to ascertain her location on the day in question.
Were you able to figure out where the defendant was at the time of the homicide?
We were. However, we were not able to figure that out based on Avery Becker's cell phone, as she had lost it.
So what did you use instead?
Instead, we subpoenaed her phone company for her call detail records. We'll just call them CDRs for short.
What is a call detail record?
CDR tells me the location of a cell tower that a person's phone connects to at any given point when they receive a digital communication, such as a call or a text. And based on that, I am able to pinpoint a person's approximate given location at any point when they receive such a communication.
Using call detail records, were you able to figure out where the defendant was at the time of the homicide?
Yes, I was. There were actually 2 maps that were prepared that would be helpful for the jury to visualize what all of this really means.
Your Honor, let the record reflect that my trial technician is displaying Exhibits 15 and 16 on the screen.
It does.
Do you recognize these exhibits, Detective Markowitz?
Yes, I do.
What are they?
Well, these are the maps that were prepared.
Could you go into a little bit more detail about what they are?
Of course. Exhibit 15 is a map that is based off of the defendant's phone records. And Exhibit 16 is that same map. However, it does also include a potential route that the defendant could have taken to get to Mr. Brackman's home.
Are these maps fair and accurate with the data you collected?
Yes, they are.
Your Honor, at this time, I move for the admission of Exhibits 15 and 16 into evidence.
Mr. Booth, your position?
No objections, Your Honor.
Right. People's Exhibits 15 and 16 are admitted.
Permission to publish to the jury, Your Honor?
Yes.
Now, using Exhibits 15 and 16, can you describe for the jury the route that matches both the time and location of the defendant's phone?
Of course. As you can see, the defendant's phone begins at the top red wedge. It pings there 2 times, which is near the defendant's home. Then we have 1 ping that places the defendant's phone somewhere between the defendant's home and Mr. Brackman's residence. Lastly, as you can see, there are 4 pings that place the defendant's phone at the victim's residence.
So what does all this mean?
To a reasonable degree of scientific certainty, this means that the defendant's phone was at the victim's residence for approximately 12 minutes during the time that the crime took place.
In your expert opinion, was Avery Becker involved in the break-in that led to the death of Mackenzie Brackman?
Yes. In my expert opinion, Avery Becker went to Mackenzie Brackman's home to trash it. And during the course of that intrusion, Mr. Brackman was killed by Ms. Becker.
Thank you, Your Honor. I have no further questions at this time.
Mr. Booth, cross-examination.
Now, Detective Markowitz, I'd like to start with talking about the crime scene. Now, when you went to the crime scene, you took photos of cast off marks on the wall, correct?
Yes, that is correct.
But they were corrupted, correct?
Yes, unfortunately, those photos were corrupted.
But when an experienced investigator like you knows to take more than one photo of each piece of evidence?
We did take more than one photo. However, an entire SD card was unfortunately corrupted.
All right. Then I'd now like to talk about what you say in your statement you got from the videos. In your statement, you said it looked like a random burglary interrupted at first, correct?
It does appear like that, yes.
So can you say, you also said that because that it looks like it could be the work of a disgruntled ex-client because of Coach Brackman's work, correct?
Originally, that was a theory that we had. However, the facts of the case do not support that.
All right. So can you 100%, you can't 100% say that it was Becker that broke into the house, right?
I can 100% say that based on all of the facts in today's case.
Now I would like to bring up the Detective Jordan Markowitz witness statement, purposes of impeachment.
You may.
Thank you, Your Honor. Sorry, just getting to Markowitz's statement. Who's that? Okay. Now, now would you please read lines 80?
Objection, Your Honor. May I be heard?
Proceed.
This is improper impeachment. This opposing counsel has not given my witness the opportunity to confirm that this is indeed her witness statement.
Mr. Booth, do you want to confirm that this is Detective Markowitz's witness statement?
Yes, yes, Your Honor. Now, Detective Jordan Markowitz, is this your statement? Is this your signature here on the statement?
Yes, it is.
So you wrote the statement?
Yes, I did.
Okay. Now I'd like you to read lines 80 through 82. Not the last sentence on the 82.
The evidence at the scene and the videos made it look to me like Brackman had interrupted a random burglary. But the fact that Brackman did criminal defense work raised the specter that this could be the work of a disgruntled ex-client.
So,
again, that seemed very unlikely, like it says in my witness statement.
but still a possibility.
It was originally a possibility, but we were able to rule it out.
Your Honor, I have the detective read another part of the statement.
You may.
Would you please read lines 188 through 190?
Of course. I have carefully reviewed this statement. It is true and accurate, and it includes everything I know of that could be relevant to the events I discussed. I understand that I can and must update this statement if anything new occurs to me before the trial.
So in your statement, I mean, I have nothing, I don't see anything stating that you said that in that paragraph, you never said that it was ruled out as you went further along in the case in lines 80 through 84 or that whole paragraph. I don't see anything stating that it was turned down.
Exactly. It wasn't stated in that paragraph. It was implied throughout the entirety of my affidavit as Avery Becker is the suspect in today's case.
Okay. Now I'd like to talk about the texts now. Now, when you interviewed Alexa Fuentes, he was not, she did not have her phone on her, correct?
No, she did not.
So she just sent you the screenshots, correct?
That's correct.
But you didn't ever follow up with a second interview to be sure that those texts were valid, correct?
It wasn't necessary. The screenshots were all the proof we needed.
You didn't check that they were valid.
They were valid.
Texts and weren't fake. You didn't see the actual phone, correct?
We didn't see the actual phone, no.
Okay. Now I'd like to talk about the maps. Your Honor, permission to show exhibits 15 and 16.
Permission granted.
Right. So start with exhibit 15, or actually 16. You say that is the case, that is the path that Avery Becker's phone followed, correct?
It is a potential path that the phone could have followed. Of course, we can't prove anything for certain.
His phone, correct?
Yes, like I just said.
So so can you be 100% certain that Avery had his phone on him at the time that these calls took place?
Based on the facts of the case, we can, yes.
But this only tracks phone. This doesn't track people, correct?
It doesn't track people, no. But based on the facts of the case, again, we can surmise that Avery Becker did in fact have her phone.
But it would say that he lost his phone on the day before the murder, correct?
I'm aware that that is what Avery claims. However, the facts of the case do not support that.
And so this area, it would easily cover more than one house, correct?
My apologies. Could you re-ask that? I couldn't quite hear what you said.
Yeah. So this wedge here, it covers more than just one house, correct?
Evidently, yes, it does.
So, and it doesn't, the phone doesn't give you an exact location within that area. It just tells you which side of a tower it connected to, correct?
That's correct.
So you can't say with 100% certainty that the phone was at Brackman's house within that wedge, correct?
Based solely on the maps alone, no. However, based on the entirety of the case, we can say that.
So you can, within the case, you can determine where Becker's phone was within that wedge?
Yes, as Avery Becker is the one who killed Mackenzie Brackman, we can say that Avery Becker's phone was at Mr. Brackman's home.
But you'd say it could have been anywhere in that wedge.
That is correct based on
No
the
further
maps
questions,
alone.
Your Honor.
Objection, Your Honor.
Yes.
The opposing counsel cut off my witness. I would ask that my witness is allowed to finish her answer.
Well, it's your turn to do redirect. If you want to bring something out, you can do that on redirect, counsel.
Yes, Your Honor. May I inquire as to how much time I have remaining?
You have 9 minutes and 6 seconds remaining.
A brief redirect, Your Honor. Detective Markowitz, how do you know that the defendant's phone was at Mr. Brackman's residence and not somewhere else in the area encompassed by that cell tower?
Because as Avery Becker is the one who committed the crime, it is evident that his phone would be at Mackenzie Brackman's home.
Did the evidence show that this crime was committed by a disgruntled ex-client?
No, that is not where the evidence in today's case led us.
Thank you, Your Honor. I have no further questions.
Any recross based on that, Mr. Booth?
Yes, Your Honor.
Go ahead.
Detective Markowitz, in your statement, you say that the phones don't always connect with the closest cell tower, correct?
I do state that, yes.
No further questions, Your Honor.
Thank you. Detective Markowitz, you may step down. Prosecution may call its next witness.
Yes, Your Honor. The prosecution calls Kyle Kuzak to the stand. And may I have a moment to rearrange my virtual courtroom?
Yes, you may. Okay, counsel, you're muted.
My apologies, Your Honor.
No,
Once again, my name is Annika Buchin, Bucchin, and the witness playing Ms. Kyle Kuzak is Pilar Melendez, Melendez.
Thank you. You may proceed, Ms. Buchin.
Good morning. Please introduce yourself to the jury.
Good morning. My name is Kyle Kuzak. I am a crime scene reconstructionist for the Denver Police Department. I'm often referred to as a CSR for short.
Ms. Kuzak, a few minutes ago, Detective Markowitz established the different roles law enforcement had in their investigation. But what was your role as the crime scene reconstructionist?
As a CSR, my job is to collect all of the forensic evidence and determine how a crime scene could have occurred. In this case specifically, I worked with the forensics team to determine how Mackenzie Brackman's death could have happened.
And how long have you been involved in the field of crime scene reconstruction?
For about 19 years now. I've been reconstructing crime scenes for the duration of my profession. Such crime scenes involve property crimes, burglaries, and even homicides.
And Ms. Kuzak, are you certified to do what you do?
I am. I'm certified under the Colorado Bureau of Investigation.
And without telling us what that expert opinion is, have you reached an expert conclusion in today's case that would be helpful for the jury?
Objection, Your Honor.
Yes.
Yes.
This witness is not admitted as an expert, so she cannot give her expert reason.
May I respond, Your Honor?
Yeah. And may I have defense counsel's name? Is it Huffman?
Yes, it's Huffman, Huffman.
Thank you. You may reply, Ms. Buchin.
Yes, Your Honor. As I said in my question, I asked Ms. Kuzak, without telling us what that expert opinion is, has she reached a conclusion in today's case? My question wasn't asking for Ms. Kuzak to testify to her expert conclusion, as opposing counsel is right. We have not yet tendered Ms. Kuzak as an expert in today's case. However, opposing counsel's objection is not relevant at this time simply because I haven't asked Ms. Kuzak to testify to her specific conclusion in today's case.
Objections overruled. You may proceed, Ms. Buchin.
Now, Ms. Kuzak, did you finish your answer?
I didn't know. But as I was saying, yes, I have reached a conclusion that would be helpful for the jury.
Your Honor, at this time, I ask that the court recognizes Ms. Kyle Kuzak as an expert in crime scene reconstruction and investigation.
Mr. Huffman, your position?
I don't object to this witness being entered as an expert.
All right, Detective Cusack will be recognized as an expert in crime scene investigation and reconstruction and investigation.
Now, Ms. Cusack, how did you first approach your crime scene reconstruction of this case?
Every case is different, but part of my job is to standardize a process so that I can come to the most scientifically sound conclusions when reconstructing a crime scene. To that end, I always follow a 5-step analysis process, and I make sure to document as much information as possible to reconstruct a crime scene to the best of my abilities.
And what evidence did you rely on to formulate your conclusions?
For this case specifically, I looked at all of the photographs included in the case file, all of the police reports, the autopsy report, and all 4 Ring doorbell system videos, and I also visited the scene of the homicide.
And based on your 5-step analysis and in your expert opinion, do you have sufficient data to properly reconstruct the crime scene and determine what happened to Mackenzie Brackman?
I do, yes.
Let the record reflect my trial technician is displaying what has been previously marked as exhibits 1 through 9, as well as exhibit 18.
It will.
Ms. Cusack, do you recognize these exhibits?
I do, yes.
And what are they?
Exhibits 1 through 4 on your screen are all photographs of the victim. Exhibit 5 is a photograph of the weapon, the knife, next to the victim. Exhibit 6 is a photograph I took of the knife in the lab. And exhibits 7 through 9 are all photographs taken in the victim's residence, specifically the kitchen. And exhibit 18 is a photograph of the scuff marks at the rear door of the victim's residence.
And are these photos accurate depictions of the crime scene that you personally saw?
They all are, yes.
At this time, Your Honor, I ask to admit exhibits 1 through 9, as well as exhibit 18 into evidence.
Mr. Huffman, your position?
No objection, Your Honor.
All right. And I apologize. What were the numbers of the exhibits again, Ms. Buchan?
Yes, exhibits 1 through 9, as well as exhibit 18.
Okay. Prosecution's exhibits 1 through 9 and exhibit 18 are admitted.
And with that, Your Honor, may I have permission to publish exhibits 1 through 9, as well as exhibit 18, and exhibits 10 through 13, which were admitted on the direct examination of Detective Markowitz, to the jury?
Yes, you may.
So let's start off by talking about exhibits 10 through 12. Let's play exhibit 10 first. And now let's play exhibit 11. And finally, exhibit 12. Thank you. You can take those down. Ms. Cusack, based on these 3 videos, can you explain what we just saw?
Of course. We just saw a perpetrator matching the general height and build of Avery Becker approach the victim's residence, the front door, which was locked. That is why we see the perpetrator matching the approach the south side of the residence and into the back door gate and then proceeding into the backyard. And lastly, we see that the perpetrator was opening the sliding glass door and entering the victim's residence.
Now let's display for the jury exhibits 8, 9, and 18. What happened after the intruder entered the residence?
The victim was alerted by the defendant's presence through the back door and through the security Ring doorbell system. Therefore, the victim armed himself with the knife as seen in exhibit 8. Then the victim at the side of this, at the side of this, struggled over the knife with the victim, and the scuff marks left behind are all portrayed on Exhibit 18. As this struggle ensued, at some point the defendant disarmed the victim and stabbed the victim in the scapula area.
Now let's display Exhibit 13, and at the end of that video, let's show Exhibits 1, 2, and 5. So let's play Exhibit 13. And now let's display Exhibits 1, 2, and 5. And Ms. Cusack, briefly, can you explain what happened to Mackenzie Brackman?
Of course. As we see in that last video, the perpetrator fled the scene moments after the homicide. Mr. Mackenzie Brackman's body was found just inside the opening of the front doors portrayed in Exhibit 1 and 2 up on your screen. Now, after the perpetrator stabbed Mr. Brackman in the scapula area, Mr. Brackman followed the perpetrator to the front door. Now, at some point, Mr. Brackman pulled the knife out of his scapula. Now, what is important to understand is that the knife had been acting as a plug. Therefore, when Mr. Brackman pulled the knife out forcefully, he nicked his aorta, which culminated in rapid and heavy bleeding that culminated in his death, mere moments after he removed the knife from his scapula.
And Ms. Cusack, finally, based on your expert opinion, is the evidence consistent with Avery Becker committing this crime?
Yes. In fact, the crime scene, all of the evidence found on the crime scene is very consistent to the motive that Detective Markowitz had described earlier.
Thank you, Your Honor. I have no further questions at this time.
Thank you. Mr. Huffman?
Yes, Your Honor. May I continue?
Yes, please.
So did you visit the crime scene?
Yes, I did.
Okay, so are you a police officer?
No, I am a crime scene reconstructionist counsel.
Okay. So have you read the police reports for this case?
Yes. The fifth step of Tom Bevel's and Ross Gardner's 7-step methodology statement allows me to create a report or crime scene reconstruction, and that would be the equivalent to a police report.
Would you say you memorized the case?
I'm not sure what you're asking, counsel.
Would you say that you memorized the report of the case?
My report for the crime scene reconstruction, word by word, no.
Honor, can I have a brief moment?
Yes.
Your Honor, at this time, the defense has used all of their time for cross-examination. Your Honor, I believe you're muted.
Thank you. Sorry, other people in chambers here are talking too loud. Mr. Huffman, did you hear the timekeeper's comment?
Yes, Your Honor.
Do you have anything to say?
No, Your Honor.
All right. Is there any redirect, Ms. Buchan?
No, Your Honor, and at this time, the prosecution rests.
Thank you. All right, is the defense ready to proceed with their case?
May I just have a brief moment to get set up, Your Honor?
Yes, you may.
Your Honor, permission to proceed.
Yes, Mr. Booth, go ahead.
I would like to call Avery Becker to the stand.
All right. And Mr. Becker is sworn in.
Mr. Becker, what high school did you graduate from?
I graduated from Colorado High School, or CHS for short.
Did you do any extracurriculars in high school?
I did mock trial.
And who is your coach?
My coach is Mackenzie Brackman.
All right. Did you have a good relation with him?
I had a very hate relationship. Me and him never really got along very well. He would often say I was lazy and late to class and that I didn't participate as well or help the team as much.
What team were you on?
I was on the A team.
And were you bumped down?
I was bumped down to the B team after Mr. Brackman said I wasn't. I was lazy and I was not good enough to be on the A team, and that I should not be. I should not be in them.
And were you brought back to the?
I was brought back to the A team after my good friend Taylor Perkins graciously stepped down to let me back on it.
What did the coach think of this?
What was that?
What did the coach think of this?
Mr. Brackman was very upset, but he had no other choice but to let me on, as I was the only one qualified to move up.
And what happened after regionals?
After regionals, after I had won Best Attorney in the State award, as well as some other awards such as closing or best closing, he had gotten back, and I was expecting a congratulations, but he scolded me for going off script, not using his pre-read closing.
All right. What happened after that?
He was very, very mad at me, and we got in an argument and started to yell at each other. And that is when we both stormed out. I stormed out grabbing a dry erase marker.
What'd you do with that dry erase marker?
Well, it was what I thought was a dry erase marker. It later turned out that it was a black permanent marker. I was going out to a brand new Porsche to write on the front hood in large ink, worst attorney award.
And what was Coach Brackman's response to this?
He was coming out to me, and I could hear him about to apologize to me, and then he had seen what I had done. And that's when he finally snapped and yelled at me for everything I had done wrong, and finally kicked me off the mock trial team for good.
All right. And how do you feel about this?
I regret everything I have done to my car, and I even offered to clean it and give it a new paint job.
Okay. Did he the day before? I would like to jump to the day before the murder. Where were you after school?
I was after school. I was at the Fry Shack with my friend Taylor Perkins. We were there to calm down and play some games on our phone.
Yeah. Did anyone come to see you? Come to talk?
My teammate Alex Fuentes came to us, but she was mostly just rubbing it in how I had gotten kicked off the team and how I was a bad student, or how I was a bad team member and that I didn't deserve what I had won.
Objection, Your Honor. May I be heard?
Yes. Go ahead, counsel.
This is hearsay pursuant to Rule 801, as it is an out-of-court statement being used to prove the truth of the matter asserted, specifically referring to the statements made by Ms. Cifuentes towards Mr. Becker. Furthermore, this is substantially more prejudicial than probative pursuant to Rule 403, as any alleged statements made by Ms. Cifuentes hold very little probative value, which would be substantially outweighed by the risk of unfairly prejudicing the jury into believing that Ms. Cifuentes bared resentment towards Mr. Becker for being kicked off the mock trial team, and as such stole his phone and framed him for this crime.
Your response, Mr. Booth?
Yes, Your Honor. Under Rule 801, Section 1, Part 2, this is it would be a statement made by an opposing. It would be an opposing party statement.
Okay, anything else?
No, Your Honor.
All right,
May I respond?
you may.
Your Honor, this statement does not apply to 801D2, as 801D2 is only applicable to the party representative, and the prosecution in today's case has no party representative. The only party representative present is Mr. Becker for the defense.
The objection is sustained. This is his hearsay. Statement by a party opponent means by a party and not a witness. So the objection sustained on hearsay grounds. I would not have sustained it on the 403 ground, but it is hearsay. You may proceed.
Your Honor, I move to strike all testimony about the statements from Ms. Cifuentes.
It's stricken. Go ahead, Mr. Booth.
All right. So Avery, when you did you leave the fry shack that night with your phone?
Could you repeat?
Yes. Did you leave the fry shack that night with your phone?
I did. I left the fry shack without my phone.
And what did you do the next day?
The next day, me and my friend Taylor Perkins spent the entire day at the mall and the fry shack looking for my lost phone.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Before I begin, just as a reminder, my name is Hannah Feeney, F-E-E-N-E-Y. Now, Mr. Becker, I'd like to talk about some things you said on direct. You said that you regret everything you did to Mr. Brackman, isn't that right?
That is correct.
But have you ever said that Mr. Brackman had a massive ego?
He did have quite the ego.
And you even went so far as to call him a joke, didn't you?
I called his license plate a joke.
And just to be clear, you said all of this in your affidavit, which you wrote after Mr. Brackman was murdered. Isn't that right?
This is correct.
And it's fair to say that you and Mr. Brackman never had the best relationship, did you?
Yes.
And this all culminated in you being kicked off the team 3 days before Mr. Brackman's murder. Isn't that right?
That is true.
And that was because you vandalized his car with a permanent marker, yes or no?
Yes, but I had no idea it was permanent until after I had wrote the words.
But it was a permanent marker, right?
Yes.
Now, let's talk about the investigation that happened. You agree with the prosecution that you skipped school on March 6th, 2020, correct?
I did.
And we also agree that you were best friends with Taylor Perkins, right?
I was very good friend with Taylor Perkins, yes.
And now let's talk about the map that you saw earlier. May I have permission to publish Exhibit 16 to the jury?
You do.
if now, Mr. Becker, can we agree that your house is in the area where your phone was at 12:47?
We can conclude to that.
All right. Thank you. The exhibit is no longer needed. Although at this time, may I have permission to publish Exhibit 14 to the jury?
You may.
Now, as you said on direct examination, you wanted to get back on the team, didn't you?
I did want to get back on the team, yes.
And that is your name in the contact information at the top of this exhibit, yes or no?
That is my name.
And in these texts, the person labeled Avery Becker tries to get back on the mock trial team, don't they?
Yes.
Thank you, Your Honor. I have no further questions at this time.
Mr. Booth, any redirect?
Yeah, brief redirect, proceed.
Please go ahead.
So Mr. Becker, just to clarify, you were gone all day on March 6th with Taylor Perkins looking for your phone.
I was gone all day.
You were gone all day? Oh, no further questions, Your Honor.
Any recross in response to that, Ms. Feeney?
First, may I inquire as to how much time is remaining?
You have 16 minutes and 42 seconds remaining.
Yes, Your Honor, briefly.
All right.
Now, of all the people who supposedly saw you at the mall on March 6th, 2020, Ms. Perkins is the only one testifying that you were there that day, isn't that right?
That is correct.
And just to be clear, Ms. Perkins is also your best friend, isn't she?
Yes.
Thank you, Your Honor. I have no further questions.
Thank you.
Your Honor, before we leave
Yes.
this witness, may we have the student witness's name?
Sorry, my name is Anders Griffin, Griffin.
Thank you.
Thank you. Thank you, Mr. Kane. You may step down, Mr. Becker. So the defense may call its next witness.
Yes, Your Honor. Will you give me a brief moment?
I'm sorry, you need a brief moment?
Yes, please.
Okay, sure, go ahead.
Your Honor, the defense would like to call Taylor Perkins to the stand.
All right. Ms. Perkins is under oath and has taken the stand.
Oh, wait, no.
And if you could introduce Ms. Orr again, just yourself and Ms. Perkins and the person who is portraying Ms. Perkins today.
Yes, so my name is Tess Orr, Tessorr, and our student who is playing Taylor Perkins is Juliet Berry, Berry.
Thank you. Please proceed.
Will you please state your name and spell your last for the record?
Yes, my name is Taylor Perkins, Perkins.
Where did you graduate high school?
I graduated at Colorado High School.
Were you in any extracurriculars in high school?
I'm sorry, may you repeat the question?
Yes. Were you in any extracurriculars when you were in high school?
Yes, I did mock trial.
How long were you on the mock trial team?
I was on the mock trial team for 4 years.
And can you tell me who else was on your mock trial team?
Yeah, Avery Becker and Alex Fuentes were.
How did you get interested in mock trial?
Avery Becker is one of my friends, and he got me into it.
And who coached your mock trial team last year?
Mackenzie Blackman.
What was your relationship like with Mr. Brackman?
I thought he was a mediocre coach and an even more mediocre lawyer.
And can you tell me what Avery and Mr. Becker's relationship was like?
We had
Objection, Your Honor. May I be heard?
Yes.
Your Honor, this is speculation pursuant to Rule 701, as Ms. Perkins will be testifying to the relationship between the defendant and the victim. The opposing counsel has not laid foundation that this is something that Ms. Perkins would know. Opposing counsel has not laid foundation that Ms. Perkins interacted with the two of them together and would know about these relationships, and therefore she cannot testify to how the defendant and the victim got along at mock trial until that is sufficiently late.
Ms. Orr, perhaps if you lay a little more foundation. Uh-oh, I think we're both, Ms. Perkins and Ms. Orr are both muted.
Yes, I apologize. There was.
Your Honor, I think it's another announcement.
Yes, I apologize. Your Honor, may I respond to the objection?
Please do.
Ms. Perkins stated that she was on the mock trial team with Mr. Becker and that she had been on there for 4 years. So I do believe that she can testify to the relationship between Mr. Brackman and Avery.
All right, objection's overruled. Please proceed.
1 moment, please. Just real quick. Would you like me to repeat my question, Ms. Perkins?
Actually, I would. Please go ahead.
Okay. What was Avery and Mr. Brackman's relationship like?
We had the same thoughts about him, but they would get into a lot of arguments about how prepared he was for practice and how he wouldn't follow the script.
Did you ever get involved in Mr. Becker and Mr. Brackman's statements?
No, I thought it was a little funny and amusing to watch their feud, but I was never involved myself.
Can you elaborate on what happened before your regional tournament last year?
Yes. Avery Becker showed up to practice late once again, and Mr. Brackman's anger reached the boiling point, and he got really angry with him, and they got into a big argument, and Mr. Brackman ended up demoting him to the B team.
Did Avery stay on the B team?
No, I knew that Avery cared about mock trial much more than I did, and I decided that I would step down because I didn't really like mock trial anyway, and it wouldn't be that fun for me to do it without him anyway.
Can you elaborate on what happened, on what you did on March 5th?
Yes, on March 5th, that was the day that Avery got kicked off the team, and he came over to my house, and we played games, and we went to the Fry Shack and found all the other people from the mock trial team there as well. And we also went to the mall.
Did while at the Fry Shack, did anyone from your mock trial team talk to you?
Yes, a lot of them came over and started talking to Avery about how sad it was that he had gotten kicked off the team, including Alex Cifuentes.
Was it unusual for Avery to hang out with, was it unusual for Alex to hang out with you and Avery?
Objection, Your Honor, may I be heard?
Yes.
Once again, this is speculation and lack of personal knowledge. Opposing counsel has not laid foundation that Ms. Perkins knows Ms. Cifuentes, so she is unable to testify if it's unusual for the two of them to talk together. I understand that the defendant and Ms. Perkins are friends. However, there's been no foundation laid and no testimony today regarding the relationship between Alex Cifuentes and Taylor Perkins and Alex Cifuentes and the defendant in today's case. And therefore, this is speculation pursuant to Rule 701.
Ms. Orr?
Yes. Again, when Ms. Perkins stated that she was on the mock trial team with Mr. Becker, she also stated that she was on the mock trial team with Ms. Fuentes.
Objections overruled. You may proceed.
So was it unusual for Alex, to hang out with you and Avery?
Yes, Avery and I did not like Alex very much, and he was kind of the last resort for us to talk to on the team.
And can you tell me what happened while Alex was talking to you and Avery?
Yes, Avery started getting really frustrated, and he ended up storming out of the room to the bathroom and left his phone on the table.
Was it usual for Avery to leave his phone?
No.
Can you tell me what happened the morning of March 6th?
Yes. So usually Avery and I ride together to school, but when I texted him, he didn't respond. And when we got in the car, when we were riding together, I talked to him about it, and we realized he didn't have his phone, and he hadn't had it all like that night.
So what did you and Mr. Becker do about that?
We ended up ditching school that day so that we could look for it. In fact, we retraced our steps in the mall, the fry shack, and we even looked at my house.
How long did you and Avery look? How long were you and Avery looking for his phone at the mall?
We spent all morning in the mall.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. May I have a moment to rearrange my virtual courtroom?
Yes.
And Your Honor, once again, my name is Annika Buchin, Bucchin.
Thank you, Ms. Buchin. You may proceed.
Now, Ms. Perkins, I'd like to talk about the detective's testimony regarding Avery Becker's phone. Your Honor, may I have permission to publish Exhibit 16 to the jury, which has already been admitted into evidence?
Yes.
While my trial technician is pulling that up, Ms. Perkins, after the defendant was kicked off the team, the two of you thought of ways to get back on? Actually, Ms. Perkins, let's talk about Exhibit 16. When looking at this exhibit, you can see the defendant's home in the top shaded region.
Yes.
And you can see the victim's home in the bottom shaded region, yes?
Yes.
And earlier today, you testified to being at the fry shack with the defendant. Am I remembering that correctly?
Yes.
And you also testified to being at the mall with the defendant, correct?
Yes.
But neither the fry shack nor the mall are in any of the red shaded regions on that exhibit, are they?
No, I was calling the phone the entire time, and Avery didn't have the phone.
So that's a yes to my question. The mall and the fry shack are not in there.
No.
Thank you. This exhibit is no longer needed. Now, let's also talk about the text messages Alex Fuentes testified to earlier. Your Honor, may I have permission to publish Exhibit 14 for the jury, which has already been admitted?
Yes.
So, Ms. Perkins, while that's being pulled up, after the defendant was kicked off the mock trial team, the two of you thought of ways to get back on?
Yes.
And that included texting everyone on the mock trial team, yes?
Yes, we even texted Alex Fuentes, yes.
That's right. And when you look at this exhibit, that's Avery's name at the top, correct?
Yes.
And the person labeled first says, "Hey, Alex, it's Avery." Am I reading that right?
Yes.
And just as you thought, this text message chain has the defendant asking Alex Fuentes for help to get back on the mock trial team. Isn't that right?
Yes.
Thank you. This exhibit is no longer needed. Now, Ms. Perkins, I'd love to talk to you about the relationship between Mr. Brackman and the defendant to the best of your knowledge. The two of you had a feud?
Alex and I, who are you talking about?
My apologies, Ms. Perkins. The defendant and Mr. Brackman had a feud, yes?
Yes.
And the feud bothered the defendant, didn't it?
Yes.
And Mr. Brackman could be mean to the defendant?
They would get into arguments, but it never went too far until he ended up vandalizing the car.
I understand, Ms. Perkins, but have you ever said Brackman was mean to Avery?
I don't think he was. I don't think he was specifically mean to Avery, no, but they would have arguments.
Ms. Perkins, have you ever said it was actually pretty mean, saying Avery didn't deserve the awards that she received? Those are your words, correct?
This is true, yes. I think it
and
was.
And the victim was, oh, my apologies, Ms. Perkins, were you finished?
Yes.
And the victim was all over the defendant about something? Your Honor, I ask that the time is paused while the announcements are occurring for opposing counsel.
Yes, let's pause the time.
Thank you.
It's over, thank you. Will you repeat your question?
Of course. Ms. Perkins, the defendant, or excuse me, Mr. Brackman was always on the defendant about something, your words?
Yes.
But it's true the defendant could be rash and had an inflated ego at times?
Yes.
And like you testified to earlier, the defendant vandalized Mr. Brackman's car days before he was killed, true?
Yes.
And then after being kicked off the team, the defendant tried everything to get back on, as we've already established.
We did. We texted everyone. And the
defendant,
Brackman himself.
That's right. The defendant tried to get back on the team the day before Mr. Brackman was killed. Isn't that true?
Yes.
And yet, the victim never changed his mind, did he?
No.
And the next day he was murdered, yes or no?
Yes.
And you would agree that the defendant is addicted to her phone?
He did love his phone, and he was on his phone a lot.
That's right. It was like a third kidney to him, true?
Yes.
But despite the fact that he was addicted to it, as you say that he wasn't very concerned about his phone being stolen or missing, now was he?
We didn't realize until the morning of, so.
Well, Ms. Perkins, did it ever occur to you that perhaps Avery Becker's phone being missing was a ruse to create a cover story for them?
Will you repeat the question?
Did it ever occur to you that perhaps Avery Becker's phone being missing was a ruse to create a cover story for them?
For Avery or for who?
Yes, for Avery.
For Avery. I believe that Avery, I am Avery's best friend, and I think that he would tell. I don't think he would do that, and I'm quite sure that he did not grab his phone.
Well, let's talk about that. The defendant never attempted to notify you that his precious third kidney was missing that night of March 5th?
Will you repeat the question?
The defendant never attempted to contact you to tell you that the phone was missing on March 5th.
How could he? He didn't have his phone.
And the defendant also didn't try to notify you the next morning before he picked you up for school.
He didn't have his phone.
And the only reason he mentioned it in the first place is because you brought it up. Isn't that true?
Yes.
And furthermore, the defendant never thought of places to go look for the phone?
No, he did. We thought of going to the mall, the Fry Shack, and the Fry Shack. Well,
Ms. Perkins, I understand it's your opinion, but have you ever said, I thought about the Fry Shack?
I do believe that we went and looked there, but I do not think that it was specifically me that came up with it.
Have you ever said, when I said something, oh, excuse me, have you ever said, when we did not find it, I remembered the phone on the table, so I suggested the front check? Those are your words, yes or no?
Yes.
And with all of that being said, you still don't think this was a ruse?
I am quite sure he did not grab the phone. I do not believe mistaken. I stand by my words.
That wasn't my question, Ms. Perkins. Yes or no, you still don't think it was a ruse?
No.
Thank you, Your Honor. I have no further questions at this time.
Thank you. Ms. Orr, did you have any redirect?
Yes, Your Honor, briefly. Okay, Ms. Perkins, how long were you and Avery at the mall together that morning?
We were there all morning.
And then how long would you say that you were at the Fry Shack?
We went there. We were there during the afternoon shift so that we could talk to the afternoon shift.
All right, thank you, Your Honor. No further questions.
Any recross in
No, Your
response to that? All right, thank you. Ms. Perkins, you may step down. And the defense may call its next witness.
Yes, Your Honor. The defense would like to call Detective Blake Van Owen to the stand, please.
All right. And Ms. Van Owen is on the stand and under oath.
Yes, Your Honor. May I proceed?
Yes, and is this Mr. Booth?
No, this is Huffman. Sorry.
I'm sorry.
Let me change the name real quick.
Okay, no, that's okay. I just, Huffman. All right, Mr. Huffman, my apologies.
You're okay.
The pictures here are little, so.
Yeah, you're okay.
Okay, thank you.
And the witness's name?
Nicholas Huffman.
No, the witness's real name?
Oh, it's McKinley Baum. B-U-M.
All right. You may proceed, Mr. Huffman.
Good morning, Detective Van Owen. Please introduce yourself to the court.
My name is Professor Blake Van Owen.
And what do you do for a living?
I am a private investigator and a professor.
How long have you been a professor?
I've been teaching at CU Denver for 5 years.
Why do you teach those subjects? That or whatever. Okay, sorry, let me rephrase my question. So, what do you teach at the CU of Denver?
I teach police practices and social injustice.
Why do you teach those subjects?
There was a situation when I was working at the Aurora Police Department in which I followed the police procedures that were in place at the time, and I've come to realize now that I don't agree with a lot of them. So I teach social justice to help other people understand.
So prior to being a professor, you said you worked at the Aurora Police Department. What did you do while you were there?
I was a police officer. I just worked in police practices.
Your Honor, at this time, I would like to offer Detective Blake Van Owen to the court as an expert in police practices.
Response from the prosecution?
I have no objection to that as long as that is all this professor opines on.
Ms. Van Owen is accepted as an expert in the area of police practices and social justice. You may proceed, Mr. Huffman.
So going to the case, did you put a report in for this case?
I did.
Thank you. Have you worked with people in this courtroom before?
I have worked with the victim of this case.
Have you also worked with Kyle Kuzak?
Yes.
Thank you. Have you ever told him, or not told him, but said that he's egotistical or full of himself?
Yes.
Okay, so going back to the case, was the knife the same as what was in the knife block?
I'm sorry. Will you repeat your question? I'm sorry.
The knife that murdered Mackenzie Brackman, was it the same as in the knife block?
It was not.
Can you explain to me how the knife entered Brackman's body?
Well, I feel like there were a lot of rushed parts to Detective Markowitz' investigation. In order for the knife to have nicked Brackman's aorta, the killer would have had to have been much bigger in build so that he could stand over the victim. Or, as we've seen from the Ring videos, that the murderer was not a much bigger size than Brackman. So I've come to the conclusion that Brackman would have had to have been sitting down, and the killer came over him with the knife coming down into his shoulder blade.
So going to the videos that have been entered in evidence, they're Ring notifications, they're Ring devices, correct?
Yes.
So you're aware that the notifications can be turned off from the Ring device.
Objection, Your Honor, may I be heard?
Yes, go ahead.
The opposing counsel just asked a leading question. You are aware that notifications can be turned off, and leading questions are not allowed on direct examination.
Response, Mr. Huffman?
Yes, Your Honor, I did ask a leading question. I'm sorry, I will rephrase my question.
All right, go ahead.
Have you ever had a Ring device yourself or been associated with them ever?
I am an owner of a Ring device myself, and I know that you can turn off the notifications on a Ring device.
Did people in this case assume things?
Yes, it was a rushed investigation with many assumptions.
Thank you, Your Honor. No further questions.
All right. Cross-examination?
Yes, Your Honor. May I have a moment to rearrange my virtual courtroom?
You may.
Now, Professor Van Owen, you've said in the past that there's no evidence of a struggle at the crime scene. Is that right?
There was very little evidence.
There were scuff marks found near the door, weren't there?
Correct, but those scuff marks could indicate many different things. They could have been there for years.
So that's a yes to my question. There were scuff marks.
Yes.
And there was a broken plate found at the scene.
There was.
And there was a chair found tipped over at the scene.
Yes.
And based on your analysis, you agree a burglary occurred, don't you?
I do.
And you agree that Mr. Brackman died during the course of that burglary?
Yes.
Now, I'd like to talk about some of the things you agree with Ms. Kuzak on. You agree with Ms. Kuzak that the description of the blood drops and cast off are consistent with the victim moving along the hallway towards the front door and with the knife lodged in his back. Is that right?
That is correct.
And you agree that the victim pulling the knife out of his back would have caused the cast off?
Yes.
And you agree that the knife would have created a plug in the victim's aorta?
Yes.
And you agree that the removal of that knife would have caused the victim to bleed to death rapidly?
Certainly.
Where we disagree is about who committed this crime. Is that fair?
Yes.
And you agree that Avery Becker is the same height and build as the intruder found on the videos, don't you?
Yes.
And you agree that the reports place Avery Becker's phone at the scene of the crime?
I don't agree with that.
Yeah. Have you ever said that the reports indicate Avery Becker's phone was at the scene of the crime?
They do indicate that, yes.
And you agree that Avery Becker was absent from school on March 6th, 2020?
He was.
Now, you make a decent living revealing where the police have dropped the ball, don't you?
I do.
And you like to think of yourself as a check on the power of police.
Yes.
However, you only worked as a police officer for 9 months back in 2005, isn't that right?
That is correct.
And you never mentioned investigating burglaries or homicides in that role, did you?
No, not as a police officer.
And after working as a police officer, you worked as a school resource officer. Do I have that right?
Yes, you do.
And you never mentioned investigating burglaries or homicides in that role either, did you?
No.
And after working as a school resource officer, you moved on to private security guard, right?
Mhm.
And you never mentioned investigating burglaries or homicides in that role either. Is that a no to my question?
That's a no. I'm sorry.
And after you worked as a private security guard, you became a teacher and a private investigator.
Yes.
And this was in 2015?
Yes, and that's my current position now.
So you've been working as an expert in this field for about 6 years?
Sure.
And during that time, you've only ever testified for the defense?
Yes.
Now, you would agree that there were probably a lot of law enforcement members involved in investigating this crime, wouldn't you?
Yes.
And with all those law enforcement members combined, there were probably hundreds of hours spent investigating this crime.
Yes.
And in order to come to your conclusions, you relied on the reports made by Detective Markowitz and Kyle Cusack, right?
I'm sorry, will you repeat it? Your question?
Of course. You came to your conclusions by relying on the reports made by Detective Markowitz and Kyle Cusack, right?
I don't feel like my testimony was based off of theirs. Is that what you're asking?
No, I'm asking, in your affidavit, you say, to come to my conclusions, I relied on the reports made by Detective Markowitz and Kyle Cusack, right?
Yes.
And you never visited the crime scene, did you?
I did not.
You never interviewed any of the witnesses?
Nope.
And you admit that you should have obtained the cell tower data regarding Taylor Perkins' phone, but you didn't you?
Yes.
Now, you say when you're rushed, you miss things. Am I right?
Yes.
And by the way, you charge $225 per hour for investigative work, right? And you charge, was that a yes to my question?
Yes, I'm sorry.
And you charge $450 for court deposition and testimony?
Yes.
So far, you've charged the defense just under $7,000, right?
Yes.
And you plan on charging them another $1,000 for your testimony here today.
Yes.
Your Honor, at this time, I have no further questions for the witness. However, pursuant to Rule 201, I ask that the court take judicial notice that $7,000 divided by $225 per hour is approximately 31.1 hours.
I don't know about judicial notice. The jury can make that determination on its own.
Yes, Your Honor.
Redirect, Mr. Huffman.
Yes, Your Honor, very brief redirect. I have a few questions. Did people in this case assume things?
I'm sorry, will you repeat your question?
Did people in this case assume things?
Yes.
Can cell phones connect to very many phone towers?
Yes, there is a large radius.
And even though you do get paid, do other expert witnesses get paid as well?
Yes.
Thank you, Your Honor. No further questions. Ms. Carrington, any recross?
No recross, Your Honor.
Thank you. Detective Van Owen, you may, or Ms. Van Owen, I'm sorry, you may step down. Are the parties ready to proceed with the closing arguments?
Yes, Your Honor. However, before I begin, I have 3 requests. Can I
right.
list those off for you?
Yeah, this is Ms. Buchan, is that correct? I'm sorry, you just cut out.
Oh, no
there.
worries.
Okay, go
It's
ahead, Ricky.
Annika Bucchin. I'll be
All right.
conducting the closing argument in today's case.
All right, so what's your request, Ms. Buchin?
My first request as a reminder is that during the course of, during pre-trial, my co-counsel reserved time for rebuttal. And so again, I ask that any time remaining at the end of my closing argument be reserved for rebuttal.
That will be granted.
My second request is that the jury instructions be constructively read into the record. During pre-trial, we decided that we would wait to read those into the record until closing argument. And so I asked for those to be constructively read into at this time.
That request is granted as well.
And finally, Your Honor, my third request is that during the course of my closing argument, my trial technician have permission to publish certain pieces of evidence that I'll be discussing throughout my closing argument that have already been admitted into evidence and that we've already sought to publish. In particular, I'll be discussing Exhibit 16 and Exhibit 14, and I ask permission for those exhibits to be displayed to the jury during the course of my closing argument, and that in jury instructions 7, 8, and 9 also be displayed for the jury during the course of my closing argument, as I will be discussing those as well.
Both parties will be allowed to display to the jury exhibits which have already been admitted into evidence.
And may I have a moment to rearrange my virtual courtroom, Your Honor?
You may, but right before that though, I'm sorry. Who was doing closings for the defense?
Nicholas Huffman, ma'am.
Oh, Mr. Huffman? Mr. Huffman, did you have any requests prior to the closing arguments?
No, Your Honor.
All right. All right, Ms. Buchin, you can go ahead and rearrange your virtual courtroom.
Thank you, Your Honor, and I'm ready to proceed. May it please the court.
Just go ahead.
You can hide behind a mask, but you cannot hide the truth. And the truth is in the map, the messages, and the motive. The prosecution and defense agree on a lot today. We all agree that a burglary happened. We all agree that during said burglary, Mackenzie Brackman was killed. And we all agree that a person wearing a mask and matching the size and build of the defendant is the one who committed these crimes. The only dispute here today is over who wore that mask. But ladies and gentlemen of the jury, that mask cannot hide the truth because the truth is in the map, the messages, and the motive. The map. Detective Markowitz showed you with Exhibit 16 the route taken from Avery Becker's house to the home of the victim. The detective explained how cell towers tracked Avery Becker along this route, placing her at the scene of the crime during the burglary and murder. The messages. You saw the text messages sent from Avery Becker to Alex Cifuentes. Texts that were highlighting Avery Becker's bitter intent. Let's hear those texts again. Well, if he's still upset about what I did to his car, then he's going to be really upset when he sees what I do to his house. I'm going to wait till he's at work, then break in and trash it. That'll show him. And that's exactly what Avery Becker did. He waited until he thought Mr. Brackman was at work, broke in with the intent to do damage, and then stabbed Mr. Brackman with the very knife he used to defend himself. The motive. As we heard time and time again today, Avery Becker and Mr. Brackman have had a history of petty fights and low blows, escalating in the vandalization of his 1986 Porsche. Failed attempt after failed attempt to get himself back on the team made Avery Becker angrier than he had ever been before. So he put on the one thing he thought would hide himself, a mask, and made a promise that he would get back at Brackman if it's the last thing he did. As the prosecution, we've charged the defendant with 2 crimes, murder in the first degree and second-degree burglary. But in order to understand murder in the first degree, it's helpful to talk about second-degree burglary. So let's do that. Jury instruction 8 tells us the crime of second-degree burglary. And jury instruction 9 spells out the crime of criminal mischief, the very crime the defendant intended to commit during the course of the burglary. When you put it all together, we've proved that the defendant committed murder, a second-degree burglary, because he entered the Brackman residence without permission and with the intent to cause harm to his property. Remember, it doesn't matter whether the crime of criminal mischief was committed, but the defendant is guilty of second-degree burglary the moment he stepped into Mr. Brackman's house without permission. So let's now talk about the murder charge. Jury instruction 7, which is displayed for you now, indicates the different elements of murder in the first degree. It says that Avery Becker committed this crime if Mackenzie Brackman died in the course of the burglary on March 6th. Members of the jury, the defense's own theory is that Mr. Brackman died as a result of the home invasion on March 6th. Again, the only question left for you is over who wore that mask. But again, we told you who wore that mask. You know that it was Avery Becker behind that mask because we showed you the map. We showed you the motive, and we showed you the messages. We, the prosecution, have met our burden of proof in today's case. Find the defendant Avery Becker guilty. Thank you.
Thank you, Ms. Buchan. Mr. Huffman,
Yes, Your Honor. May I proceed?
please do.
May it please the court. Opposing counsel, members of the jury, ladies and gentlemen, thank you. In this case, the defense questioned Detective Jordan Markowitz, Kyle Kluzak, Alex Fuentes, Blake Van Owen, the defendant, Avery Becker, and Taylor Perkins. The defendant, Avery Becker, is not a killer, but a simple used-to-be high schooler, very committed to mock trial. He was supported by a very good friend when he got wrongly kicked off of the A team. After a case where he simply did things different than his coach, afterwards, his friend Taylor Perkins texted him saying that what the coach did was unfair and that he would quit the mock trial team. So Mr. Brackman would have to put him back on the A team. Eventually, a disagreement got too far and Avery Becker got kicked off the mock trial team. And then when Avery was outside, he saw the coach's car and wrote on it with a pen. He thought with dry erase, worst attorney award. This got rid of any possibility of getting back on the team. Once he got home and had time to think, he tried to talk to Mr. Brackman, but he wouldn't talk to Avery at all at this point. All he wanted to do was reverse his bad decision. He offered to get a job just to repaint the coach's car and tried to get others to see if they would be able to talk to the coach since he wasn't willing to talk to Avery. If he felt guilty after riding on the car, he would look much more guilty after killing the person he was just trying to talk to so he could get back on the mock trial team. He left his phone at the Fry Shack, and the next day he was searching for his phone with a friend named Taylor Perkins. And did Detective Markowitz bother to track Taylor Perkins to see where he was? No, he didn't. This all seemed excessive, but it all points to the undoubtable fact of Avery Becker's innocence in the murder of Mackenzie Brackman. Thank you, Your Honor.
Thank you, Mr. Huffman. Ms. Buchan, I'm not sure if there's any time left, but if there is, you may use it for rebuttal.
Yes, Your Honor. May I ask how much time I have remaining?
You have 59 seconds remaining.
With that, Your Honor, I will conduct a rebuttal.
Please.
Now, throughout opposing counsel's closing, they said a lot of things. They criticized the prosecution's investigation in today's case. They called it flawed. They called it rushed. Members of the jury, there's no way for it to be flawed or rushed because Kyle Kuzak and Detective Markowitz looked at every piece of evidence. And unfortunately for the defense, every piece of evidence, the map, the motive, and the messages all pointed to Avery Becker committing this crime. Not only that, but opposing counsel posed this mantra of innocence for the defendant. But we discussed the motive that the defendant had to commit this crime. There is no innocence in today's case. Find the defendant, Avery Becker, guilty. Thank you.
All right. Thank you, counsel. Ladies and gentlemen of the jury, you may now retire to discuss this case and render a verdict. So procedure-wise, scoring judges, do you need some time to do your calculations?
Your Honor, if I may, this is Amanda Shepard, scoring judge.
Yes.
I had 2 points of clarification, just quickly on the names of the students. The witness, Mr. Griffin, first name Anders, is that correct? Anders?
That's correct.
Thank you. And the second witness, characterized by Miss Baum, Baum, McKinley, first name?
That's also correct.
Very good. Thank you so much.
So Ms. Shepard, Mr. Kane, how much time would you need?
I'll be ready to submit very shortly.
Same for me.
All right, why don't we just, I'll just stay in recess, but stay at our monitors and wait to hear from the scoring judges.
Your Honor, I have submitted.
I have as well.
Okay, and I'll take some suggestions here. I've been a scoring judge before. I've not been a presiding judge. What is our next step here? If anybody wants to give me some thoughts, I'm open to them.
Typically, Judge, the scoring panelist, excuse me, I'm printing my ballot if
Oh, sure.
there's noise in the background. But typically, the scoring panelists make some comments. Judge Timbreza said we should limit those to 3 minutes each.
Okay.
And
Well, then
I don't know if Chris Ballard is able to chime in or not. You may want to see if there's some way to confirm with him that he has submitted.
Mr. Ballard, are you with us or have you had a chance to submit your scores? Is there any way to let us know? You know what I might do is send an email to Mr. Sterrett and see if he's heard from Mr. Ballard. Or if he's been in communication with him. Okay, I've just sent an email to Mr. Sterrett and to Judge Timbreza. See if they've heard from Mr. Ballard and if he wishes to participate in the comments. And you know, I have a phone number too, so let me try to call someone. I'm going to go on mute.
Hey, I'll take a second, Coach Zach, and say great job. You always have great teams.
You as well. All the kids did great in this round. So wonderful.
Yeah.
All the students.
Yeah, definitely did. It's good to see you again.
Even virtually, right?
Even virtually. Maybe next year we'll get back to normal. So, but no, your kids look great. They always do.
You as well, Coach.
Hey, thanks.
Okay. Mr. Starrett and Judge Tim Braze are waiting to hear from Mr. Ballard, but in the meantime, they suggest that we go ahead and start with the comments from Ms. Shepherd and Mr. Kane. Whoever wants to go first, please go ahead.
Well, I guess that's me then. Congratulations to all of you for putting on a really good trial and to adapt to the circumstances under which you have to put it on. It was awkward and a little nervy for me to try to figure out how to take care of the technology today, and to do it in a courtroom setting was really, really well done, and I congratulate all of you on that, particularly the way you were able to develop the technology to use the exhibits. I'll have a few specific comments. Ms. Feeney, I thought your opening was really, really good. I noted that you started out with a theme. I also noted, and having done mock trial for many years, that you actually discussed the charges and the elements of the charges that were required to be proved, and then developed facts and motive. So I thought your opening was really outstanding. Couple of suggestions for the prosecution team. I don't think you have to ask the judge to let the record reflect or to be heard on objections. If you want to bring up an exhibit that's already been admitted, you just can say, please bring up exhibit 14. It's in evidence. Everybody knows that. You don't have to suggest that ask the judge to agree with you that the record reflects that exhibit 14 is now on the screen. Ms. Malloy, I think you were a very confident and good witness. I also thought that you stretched on saying that you were 100% certain that Avery was at the house at the time the murder was committed, and a couple of other things. 100% is not, it's not required. You're required to prove things beyond a reasonable doubt. B, there's enough gaps in the evidence that suggesting that you're at 100% is simply wrong. And it exposes you to cross-examination, which Mr. Booth took advantage of in cross-examining you on statements that are in your affidavit that suggest that it's not 100%. So I think you should be careful about that. Ms. Orr, you tried to impeach Ms. Cifuentes and ended up bringing out a part of her statement that I don't think could have come in, except for the fact that you brought it out yourself, that you actually brought out an attack on Avery Becker's credibility that is contained in her affidavit at the very end. And I would encourage you to be careful about when you want to impeach somebody. Everybody wants to impeach when they hear something that they know has not been said before, a little bit differently. But that, I think, was harmful. In addition, for the defense case, I think your case strengths are the alibi and the and in addition to the criticisms of the crime scene investigator, Blair Rollins, who is an alternate suspect, and we heard nothing at all in the trial about Blair Rollins. If you have the ability to work that into your case at this stage, I think you should consider it. But even if you don't the witness testimony tended to start for example, when you called Avery Becker as the first witness, I thought that was appropriate. But you started with his bad conduct, riding on the car. And I think you should start with the alibi first, and the evidence that he needs to explain why his phone is getting pinged near the scene of the crime. So I think you want to start with what's important, and the same with when you call Taylor Perkins as a witness. She was your alibi witness, and I think that her testimony could have been stronger because alibi, if the jury is going to believe the alibi, you're going to get your client acquitted. And so put some more meat into that alibi defense, and finally have your client deny that he's the perpetrator of this murder. So those are my comments.
It's difficult to follow Mr. Kane. He's got several years of experience. So those are excellent notes. I would second all of them. And also like to point out, Ms. Buchan, your closing argument, as well as objections made throughout the proceedings, were well heard, well delivered. So really strong part on the prosecution. I would just say, as far as for the defense laying out, I would spend a little more time, building up the character. I mean, it's evident that Mr. Becker had, a strong character. He was an exemplary mock trial student. Spend a little more time, preaching that to the jury. I think that would have gone leaps and bounds for you there. And possibly just spend a little bit more time knowing your case, knowing the evidence that's in front of you, a little less time reading script. I think that detracted a little bit from your case overall, but I think you guys did a great job. I want to say a huge kudos to your trial technicians for getting the evidence up on the screen. It was very easy to follow. And so I know that's a difficult challenge to do in a setting like this, but you guys did an absolutely phenomenal job, and keep doing the good work. So that's all I have for you.
Okay, and we still haven't heard back from Mr. Ballard, but if I can jump in, just a couple of things. I was very impressed with everybody, and whoever the trial techs are, I would be very happy to have names and contact info for next time I'm able to do a jury trial. So I have no clue how to do what they did today. It was very impressive. I'm still used to big sheets of paper and magic markers and stuff like that. So that was very, very impressive. I thought all of the witnesses, I thought, did an excellent job, knew their material. I particularly liked the exchange with Ms. Perkins, Taylor Perkins. Ms. Berry knew her part well, responded well under cross-examination. Ms. Buchan did a very good job of cross-examination, but I thought Ms. Orr did well in responding to the objections from Ms. Buchan. She was able to stand up and not just back down. Did kind of wonder why we didn't hear anything about Mr. Rollins, but maybe next time we can try to bring that up. And I did agree with Mr. Kane that an expert rendering an opinion that it was absolutely Mr. Becker who killed the victim would draw major objections at a trial, and I don't think we'd get past the objections. But all in all, I can tell all of you spent a lot of time with this, and as always, very impressed with the dedication that you've all put into this, and with what the coaches have done to work with you as well. So thank you for letting me be part of this. I always enjoy it. Is there anything else I should be doing, Mr. Kane, Ms. Shepherd?
I can't think of anything, Your Honor.
I can't either unless some of the coaches or participants have questions.
Sure. Anybody have anything?
Thank you very much for your time. I really appreciate it.
My pleasure.
Yes, thank you very much.
Great. Well, everybody get a little bit of break, and we'll talk to you later, or we'll see you later. I guess not at the courthouse like used to be, but on screen. Bye-bye.